Hey guys, we're going over the Richard Allen's attorneys in front of the Supreme Court there in Indiana. This is live coverage, guys.
Hearing this case, written for mandamus, prohibition case. Representing the relator today, we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Karen Winnicky. Good morning, Ms. Winnicky, and Bernice Corley. Good morning and welcome, Bernice Corley. Representing the state of Indiana, council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, right? Second, all right. You just listed first, honey. Got that. So Matt Blunt, representing Judge Fran Galt, will be arguing first. Council table, we also have Chris Stake, who's also here on behalf of the respondent. Correct. Good morning and welcome, Mr. Stake, to council. Councils, we've been conducting oral arguments. You'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes. Are you ready to proceed? All right, Mr. Lehman.
Hey there, guys. How you doing?
Help protect your highest priorities with budget-friendly rates.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that the court intervene and invoke its inherent authority to supervise the conduct of the courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This is time to right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes. And his licensed counsel both will remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. The judge crossed the very objection of Mr. Allen's and went into the realm of his when he's licensed counsel saying, this is what I want, this is what I desire. The judge is without jurisdiction and has an absolute duty to act upon the client's wishes.
There was a judge here, more accurately phrased, that he's under a duty to let them back into the case. He's not questioning the jurisdiction.
When you talk about absolute duty, a court, we have cases on a member bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion that the trial court judge has.
There's an absolute duty to follow the client's wishes, and when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
The absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of...
Hi guys, are you enjoying your day today?
This constitutes three situations where in the totality, they clearly placed a limit on the judge.
Is there a reason why you filed a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserve that issue and develop a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that.
You have a lot of concerns, but I've had a couple. You have a lot of concerns with the issue.
I don't think in judicial history has ever any defendant had his defense attorney stripped.
He had never filed it, so correct?
Yes, I think when he signed it, they were outside the 7th day, but the speedy trial.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and final time.
So they sat on it, they had it for 2 months and didn't file it. Your client signed it in August.
Yes, Your Honor, they had it and did not file it. One, there would have been a reason to file it, they had a baby. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But, Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates Attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants Attorneys Baldwin and Rosie on the case. He wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on, was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct,
Hi guys, welcome to the live stream.
she did follow from those findings.
Because the attorney, the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he is developing.
What concerns? Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were you to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regard to the disclosure of the Western's material. He filed with the judge. I'm aware of that. I know what's happening. I'm ready to ride
I need you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the West, if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under the court's case law. You bring the defendant into chambers, you say, listen, in Lada, he's representing your wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical
She
violations.
thought his representation was grossly negligent and incompetent.
She said you're grossly negligent lawyers. I don't know if it was about trial representation at all, and in the arguments that she advanced in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen. And if there was a hearing where these matters were discussed and fully vetted, then either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge just, there's no foundation for the concerns that she's had. Yes, Judge.
That's really what I'm struggling with. Our original jurisdiction is very limited, and so if we were to agree with you on the substantive arguments that you made, why is it that the regular appellate process is wholly inadequate?
Justice McGough, interlocutory review and direct review are
Son of a
impossible
bitch.
and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent years and years developing a well-thought-out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of water from the judge who seized their authority. And so what we would have began that interlocutory review process by putting a motion in front of the judge asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winnicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Alden and Rosie, who we've been working with for over a year to develop and get ready to use that prosecutor on her back foot with a well-developed third-party guilt strategy that was going now.
We would have a record that they had agreed to withdraw, correct? And would have gone to hearing.
I don't think they would have had a full record even then, Judge. The judge was saying that there was the coercive action of the judge. I'm going to go out there and I'm going to say these things, and Mr. Rosie presses at her, well, what's that proceeding going to be? And the culmination of it, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better, and in fact, it would have harmed Mr. Allen even more, because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we leave your
You're
Honor.
saying there's not enough of this, but there is enough of that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
Correct, Your Honor. I do think that's, I don't think the positions are inconsistent. There is no evidence of incompetence, certainly no evidence of trial incompetence, which is what this is.
So my concern is getting this case back on track. All right. So your argument is that you have a constitutional right to counsel of choice in this circumstance, and you acknowledge that there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error, it would be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just a choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself. Because the right to counsel is meaningless. If a judge can say, stop all the work, I know you've got a relationship going on, stop it all until you come to my chambers. And then says, you're off the case, whether you go into the courtroom or you stay in here, you're off the
A lot
case.
of events in this case that led up to that hearing, correct, with regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that occur up to this point with regard to releasing discovery or letting third parties have access to discovery. Is there no line that a good judge, let's say that everything was turned over and counsel didn't show up for hearings, is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, court-appointed counsel, I do not think you're going to hear trial, you set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on the Strickland effective assistance of counsel and say, my attorneys were not effective. I mean, I lost because my attorneys did X, Y, and Z.
The not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point.
Not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
If a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, then the lawyer will be removed from the case. Excuse me, the lawyer will eventually himself pull out of the case or a conflict of interest will develop. And we see that in some of the other cases across the country. So, like, if a lawyer in one case was obstructing justice, was literally going behind the scenes, talking to co-defendants who are represented, trying to manipulate their testimony, the judge at that point just proceeds forward the law on conflict of interest. It says, calls forward those witnesses, says, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable, am I understanding your position right?
I think there are rules that actual conflict of interest is an unwaivable rule when you sue one party versus the other, and shockingly that seems to have happened in one of the cases in Indiana. So I think that other conflicts are waivable conflicts, other than that one rare exception.
How's everyone doing today?
Justice Slaughter about the waiver. So let me ask it this way. If we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR or post-conviction relief proceedings a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court will build regarding those. No, sure, no, I'm going to change that, Justice. No, because these issues have nothing to do with effective representation in the trial. So I don't think you can pursue them on those grounds. So I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to the press that the government was putting out, I don't see how those issues affect this trial. So I don't think he gets a post-conviction relief through that because those issues don't affect trial strategy.
But you're saying it would lose on the merits, so you're not willing to concede that it would be wavering. And it seems odd that he could have it both ways. That he could say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that might be affecting his trial and fully and fairly advise him that's a repercussion. But if he, when he's fully and fairly advised of that, the repercussions of that, the judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving. So,
Counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge, or are you saying if the judge finds it, you still can't remove him?
Well, this record does not support ineffective assistance to counsel.
But even if it did,
No, I'm sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that would constitute ineffective assistance to counsel for a Sixth Amendment violation, so if we were to get to that point, and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did had nothing to do with trial. But let's assume for a moment that she cited a reason. There's an intimate relationship going on. She pulls them in, goes into the chambers, and said, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest, it's a violation of ethical rules, and there's a disciplinary proceedings that I'm going to be referring for him. Do you want to go forward with this representation? And the client says yes. I think you've got a waiver of ineffective assistance to counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, in that case, it was a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of the trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it. The judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive an ineffective assistance to counsel claim. That's well-established case law. It's just none of these things the judge cited have anything to do with ineffective assistance to counsel. These are purported ethical violations. Not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples. These are good examples of that. The inadvertent disclosure of pretrial discovery has nothing. The alleged violations here have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask, with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process. And in fact, I believe that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think the court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow, would even if found, would substantiate the rule.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar?
No, I think if there's a concern, say for example, the pretrial policy, the press release, if you say, listen, I think the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge can have a hearing, let's provide proof get some sort of sense as to how this has affected the jury pool or what prejudice the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record at least fundamental error, maybe structural error that's reversible?
Trials are shown. It's a practice only trial, Judge. I think and that's why we came here as fast as we could. Because if we do not get something done now, the victims are going to be hurt, the public is going to be hurt, and the entire Indiana judiciary is going to be harmed. Because this trial has been pushed off until October, and when the judge said it in October of 2024, one of the lawyers, I believe, even represented me, didn't think we were going to get that done. Everybody's hurt, and we're going to delay things.
And you think that Gonzalez-Lopez, president of the U.S. Supreme Court, would dictate that outcome?
I think it's structural error, yes. So, and this trial is going to be for practice only. And we have the built-in error. The only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys involved with Rosie back on the case. Get this case set for trial in a time frame as fast as our law allows, which is 70 days. And that's what we really request. Thank you very much.
Thank you, counsel. We'll hear from you again on the rebuttal. Mr. Goodwin.
Chief
Chief Justice Rush, and may it please the court, I am Matthew Kwan, representing respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims such as those that Mr. Allen raises here through the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that 2 different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule, and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers, but it's hard to look at this record and not get the impression that perhaps rightfully so the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Week, the trial court, when exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Week, there just needs to be the possibility of ineffective assistance
But I'm like
counsel.
struggling with that. I'm butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition, filing as private counsel of choice. That's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in June with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing, we don't have findings. You've got a constitutional right to counsel. And he's choosing his counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Week, as well as a lot of this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're very, and I'm putting Chief Justice Shepard in the Knox case saying a judge has a very limited right to tell someone who their attorney can be. They just decided not to go with the parameters there because there was an agreement to withdraw.
Week is the opposite, Your Honor. Under Week, the trial court's discretion, when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Week says is the trial court is to be given substantial latitude, is to be given wide latitude. What Week says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Week says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily rested.
And I don't see Week, and I've looked at Week several times, as strong as what you're doing, and I think what you're doing is you're butting right up against constitutional protection, and you're doing it at your peril, and this court would do it at this peril, with regard to a case possibly having to be tried twice and having all the everybody going through it again.
that exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
Isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions we don't review discretionary issues, especially not issues to form a first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court, one way or the other, whether this was aired?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles that Mr. Allen cannot hail based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for a matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even ask for this relief from the trial court. The court doesn't ask grant writs. So I think you would be doing structural damage to your original action jurisprudence and frankly then open up the floodgates, because these kinds of pre-trial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get into business of addressing the merits every time a criminal defendant raises a pre-trial constitutional violation, you'll be flooded with these kinds of actions.
So you're
Also, I think that counsel's Mr. Lehman's argument that no meaningful appellate right exists is just wrong.
Well, that is absolutely wrong. Hannah reflects that Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel, and on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can be any serious question that these kinds of claims for Sixth Amendment violation of the right to select counsel are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. So the Supreme Court
I am having technical difficulties and I am working on it.
Relief on appeal is somehow inadequate for a Sixth Amendment violation.
What you're talking about in the ordinary courts would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedents of state versus typical?
Guys, I am having technical difficulties and I am working on it. I do apologize.
State versus Tippecanoe County. The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted it through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has the conflict to prosecute a case. In that case, the trial court had no
had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Weed, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done, but there's a way to get you to it. And it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented to them back in chambers saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of
So
procedure.
there's no process involved at all for taking no hearing, no, I have a suspicion that this is going on, I think you're incompetent, and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of the hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had noticed that the judge was considering disqualifying them. They had noticed on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with her client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have
Okay, guys, I'm back.
And I'm going to withdraw. That's his choice.
The studio I'm using is having some glitches today, so that's what's going on with that. That's why my streams keep messing up today, is because the studio I'm using is glitching all to heck today.
She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
I do know, because she said then at the hearing on 31st, it's changed. So, which means,
Well, we wouldn't have happened at a hearing. But you're right. I certainly acknowledge that she probably wouldn't have changed her mind.
Now, counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you do in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Weed, there doesn't have to be a finding that they were actually ineffective, but there has to be a finding of. This is under Weed.
So can someone leave me a comment down in the comment section on how they feel about Richard Allen's defense attorneys being stripped away from him
Allow the unauthorized disclosure of
and going to the Supreme Court to try to get them back?
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself says the likelihood of public backlash is significant, and this case serves no legitimate public purpose. The reality here, as we all know, is that we already have included a jury pool because of the inordinate pre-trial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial board is rightly and appropriately able to exercise under Weed, and I quote, intuitive and judgment based upon experience find that if counsel is capable in the retrial stages of making this many mistakes, what manner and magnitude during trial is counsel
I
capable
keep
of
getting back
making?
to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants them to be his attorney. And so you're spinning and spinning and spinning on this thing. Delay, he wants these attorneys. There's not going to be these findings with regard to incompetence. There's a lot of word out there, but let him have his attorney. Get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that's in his best interest and get this case moving again.
Let me answer that in two ways. First, beginning in Wheat. The accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived
It's a
that
8-year
conflict.
conspiracy with a lot of different people playing, in the Wheat case. I don't think Wheat is tough as neatly as you find.
Wheat
Go outside Wheat and give me something else.
Well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based upon
Where can you point to me, say, with regard to saying somebody is incompetent or negligent? We have a string of cases, so these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it's certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So could the judge disqualify the prosecutors too?
Well, again, a judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsel's asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be. That any leak of crime scene photos or anything like that can lead to disqualification of counsel on either side. I think your position. What?
Your Honor, our position is, under U.S. Supreme Court precedent as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts can reach exact opposite decisions in matters that rest with discretion, it doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Bell suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor into consideration when exercising discretion?
It doesn't have to be a factor, it certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, we went out of its way to say this decision can be based upon intuition and judgment based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Dupont, I guess more to the issue before us, when we're deciding whether or not the...
Hey guys, I want to hear from you in the comments if you guys feel that this is unfair that Richard Allen was denied his defense team and the only way to get them back was to go to the Supreme Court of Indiana.
Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold conditions to seeking relief. Whether we give relief through an original action or we're concerned that there should have been more process afforded for this issue, more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, and whether we reinstate counsel or remand with current counsel and say you need to go through this process, that saves time in the long run.
Well, let me, perhaps, we don't know, but let me offer this.
Protect everyone's interest in finality.
Yeah. We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because he was moving counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself was already acknowledging, and then see if he has a knowing and intelligent interest in having counsel continue that clearly, on this record, is engaged in conduct that's detrimental to his defense. I have exceeded my time, so I will yield the remainder of my time to my good friend, Ms. Sanchez.
May it please the Court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the Court, or the nature of the rights that Mr. Allen counseled today to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, where the party of interest is the court, forced to act as advocate in defense of itself.
What would be the harm if because of the necessary delays in backing up and going back through again, reinstate counsel, and if the judge is correct, then that weeded itself out, there'll be a hearing, it'll be done a proper way in the trial court, and then come back up.
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's general caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, and they chose to withdraw to avoid the hearing, a hearing in which the state was prepared to present evidence that may well have been about an act of that investigation, evidence that may well be relevant to full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding, and elucidation of the concerns. So, a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just cast with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the proceeding function, and for the fact that everyone will
Do you agree that with,
3D.
under the U.S. Supreme Court precedent?
Oh, I see what
If
the
there's a
fucking
mistake
problem
made in
is.
this case with regard to a defendant's constitutional right to counsel of his choice, he can go through this entire process and have to do it again if there's a conviction.
The state is concerned that if you look at what happened on October 31st, that is a very ambiguous series of events there. If someone were to
Turn off
that
the
what
fucking
happened there was, in
360
fact,
camera.
Mr. Allen, it's a personal right to choose your counsel. If he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern to the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel and the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise, and we need to know that Mr. Allen is in fact the person who was making that choice, and he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case, and then of course that he has the information he needs to make that as a knowing and intelligent exercise of the constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
It's Big Fitness Energy Sale at Planet Fitness. Join today for 24 cents down, $10 a month. Cancel anytime and get energized in the judgment-free zone. Never intimidating, always free fitness training and equipment for every workout. Join today. Deal extended through January 19th.
There is presumption, highly significant weighted. At the end, the desire of the defendant, the state agrees to either retain his counsel that he's had is a factor a court has to consider and can weigh amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial or his representation to all of the other issues of professional deficiency.
And are you aware of any other cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety
I'm having
around the country for various conduct that's